Good afternoon, everybody. I'm John Cheneau. I'm a senior associate with the Regulatory Assistance Project, coming to you today from my home office in Fort Collins, Colorado. And if you aren't familiar with who the Regulatory Assistance Project are, we are kind of a niche non-advocacy, non-profit organization that helps public officials address challenging issues in the power sector. And we're staffed mostly by former utility commissioners and utility commission staff, consumer advocates, environmental regulators, and similar people who've either worked for or been around government decision makers for a good bit of their career. I'd be happy to answer other questions about who we are, but that's RAP. I wanted to say a little bit about kind of the ground rules or the etiquette we're going to use on today's webinar with this GoToMeeting platform, and then we'll dive into the content. The first thing that I would encourage you to do is if you have problems on the right side, well, I guess it's not always on the right, it's depends on your settings, but you have a GoToMeeting control panel, and there is a chat box there. And if you're having trouble with your audio, please type a message into the chat box, and Jake, maybe you can monitor that and see if you can help anyone who's having audio trouble. We will also use the chat box if you want to raise a question and don't really feel like talking over the phone. But the first thing I'd like to ask people to do is to mute themselves when they are not talking. And again, on that GoToMeeting panel, there's a button that looks like a microphone, and you can it's a toggle between mute and unmute. And that will help us eliminate background noise. If you're not muted, it's also helpful to silence your cell phone or anything else that might make noise. So if you do want to talk, you can unmute yourself and speak up. Or if you want to raise a point without talking, you can type it into the chat box. And I think that's about it for the GoToMeeting logistics. So let's get a little bit onto the agenda. We're going to start today with introductory remarks from sort of the convener here, Michelle Repholz, and myself. And then we're going to have presentations from two guest experts. We're going to hear about the Federal Trade Commission Green Guides and residential solar issues from Hampton Newsom. And we're going to hear an example of some of the solar consumer issues that are arising in Connecticut from Ellen Swanson Katz, who's the Consumer Counsel for the state of Connecticut. We're going to have plenty of time at the end for question and answer. And I think the last thing I want to do before I give Michelle a chance to introduce things here is to sort of go through the attendees. And what I'm going to do is I can see a list of attendees, and instead of having 3 people talk at once, I'm going to read them. And if your name isn't called, then please speak up and let us know that you're attending today. For RAP, we have Jake Brown and myself, John Cheneau. We have our guest speakers, Ellen Katz and Hampton Newsom. And then the other names I'm seeing here are Hannah Terwilliger, Janet Gonzalez, Michelle Repholz, Michelle Rozier, Sally Ann McShane, Susan McKenzie, and Kelly. Is there anyone who wants to announce themselves that I haven't mentioned? Or maybe Kelly, you could share your last name with us. And I'll just pause there. Is there anyone that I haven't mentioned who's in attendance? Okay. with that, Michelle, did you want to make some opening remarks before we dive into my own?
Sure. My remarks will be really brief. Can you hear me okay?
Yes.
Great. Yeah, so we contacted you. I reached out to you guys a couple months ago to WRAP because we were looking for some guidance from other regulatory agencies. Solar has really started to take off in Minnesota, and we just want to, if we can, learn from others who have more experience. And so we're very thankful that you agreed to put this together for us, John, and we're very thankful and grateful for any wisdom that Hampton and Ellen and John, you could share with us today. That's really all I had.
Great. Thanks, Michelle. So let's get started. No better time than the present. I do see in the chat box that Kelly Martone from the PUC staff. So all are welcome, and let's get the party started. So what I wanted to do was just make a couple of brief points, but really we're featuring Hampton and Ellen today. One of the points I wanted to make is that there's a whole range of issues relating to consumer protection for those consumers who want to have or benefit from solar. But Hampton and Ellen are going to address a lot of those. So I just wanted to sort of focus in on a couple of points that aren't featured so much in their own remarks. And the first one here is I wanted to share this map that I made of states that have adopted mandatory disclosure requirements. So one of the consumer issues with solar is the question about whether consumers really know what they're paying for or what they're buying when they sign up to have solar put on their roof or when they sign up for a community solar program. And what you can see here is that a number of states have decided that part of the answer to that challenge is to make sure that consumers get standardized information. So they've created mandatory disclosure requirements for vendors who are offering rooftop solar to customers or offering community solar programs. And I'm aware of 4 states that have now adopted mandatory disclosure requirements for all rooftop solar transactions. Those are the ones in green. Some of these might still be in the place where there's a law that is directing the PUC or another entity to develop rules. So the rules, I'm not certain that they're final in all 4 of these states, but all 4 of these states in green are adopting mandatory disclosure requirements. And that means that every consumer who's considering solar is going to get the same types of information, sometimes on the same form or in the same format, from anyone who's trying to offer them solar, rooftop solar. And then similarly, you can see that there are 3 states, including your own in Minnesota, that have adopted mandatory standardized disclosure requirements for community solar. And I think as you hear more from Hampton and Ellen, you'll start to understand that a lot of the challenges for protecting consumers come down to do they understand what they are getting into? And these mandatory standardized disclosure requirements are definitely emerging as one approach that a number of states think are important for consumer protection. So that was just one thing I wanted to feature. And the other thing I wanted to feature, which you won't see so much in the slides from Hampton and Ellen, is just to reassure you that there are quite a few helpful resources out there that address different aspects of consumer protection. And this is by no means a complete list. I probably should have said on the last slide that I can't guarantee you that the states I had colored in there are the only ones that have mandatory disclosure either, because this is a kind of a fast-moving area in public policy. But what I've listed here is a sampling of some of the resources that I believe are potentially most helpful and most current for understanding the issues with solar that are most likely to bring about either consumer protection issues or publications that offer potential solutions to those issues. And you can see here that we have some publications to suggest from the Clean Energy States Alliance, Interstate Renewable Energy Council, the Solar Energy Industries Association, so that's from the solar industry itself. And I do want to note, I don't know if this is true of any of the other publications, but that one right in the middle there from the Solar Energy Industries Association, their residential consumer guide is available in both English and Spanish. So far, that's the only resource I've seen that's in any language other than English. A woman named Barbara Alexander, who's a long-time and very well-known consumer advocate, has a great publication on with recommendations for protecting consumers. And then the Louisiana State University Ag Center has a guide there as well. We'll be sharing these slides with you, and I'll just note that each one of these has a link to the online publication. And I think those are the only points that I want to make before we really get started here. What I wanted to do was introduce you to the main event, your guest speakers here. The first speaker is going to be Hampton Newsom. And Hampton's an attorney with the Bureau of Consumer Protection at the FTC, at the Federal Trade Commission. His primary duties involve energy-related consumer labeling and green advertising claims. Before coming to the FTC, Hampton worked at the Nuclear Regulatory Commission, where he specialized in environmental law and nuclear materials issues. So Hampton will be up first, and then after Hampton, we're going to hear from Ellen Swanson-Katz. Ellen has served as consumer counsel for the state of Connecticut since October of 2011. And the consumer counsel there is the public advocate on matters related to electricity, water, gas, and telecom utilities. Ellen is also currently serving as vice president of the National Association of State Utility Consumer Advocates, or NUSUCA. And she's on the advisory committee for the Critical Consumer Issues Forum, which is a joint initiative of NUSUCA, the National Association of Utility Commissioners, and Edison Electric Institute. So Ellen's extremely well placed and extremely well informed about today's consumer protection issues. Prior to becoming consumer counsel, she practiced at law firms in DC, Boston, and Hartford, and served as assistant counsel at the Connecticut Department of Environmental Protection. At their request, I guess what I wanted to say was we'd sort of prefer if people hold questions until after each speaker's finished their prepared remarks. But I want to encourage you to unmute yourself and speak up or type something into the chat box. If they say something that you simply didn't understand or you couldn't hear them and you need them to clarify it so that you don't lose the rest of the content. But sort of probing questions and further explanations, I think we'd prefer that you hold them until after they've finished their prepared remarks. And with that, if you will just forgive the little screen jump here, I'm going to turn this over to Hampton. And Hampton, you have the floor. You'll need to unmute yourself and let me know when you want me to advance the slides.
Okay, great. Can you hear me?
Yes.
Okay. Thanks so much for having me. I appreciate the opportunity to talk about these issues. As John said, I'm Hampton Newsome. I'm an attorney at the Federal Trade Commission in DC. And just a little note to get out of the way, the views that I express here are those of the staff, and they don't necessarily reflect the views of the commission. Let's go to the second slide. So FTC is a small independent agency. We have a dual role, basically. There's the consumer protection side, and that's where I work, and then we also have a antitrust bureau. On the consumer protection side, we deal mainly with advertising, deceptive advertising, and fraudulent practices. We also have some consumer labeling programs, and the basic statutory authority that we have is Section 5 of the FTC Act, which basically declares that unfair or deceptive acts or practices are unlawful, and most states will have the same authority. And so the things that I'll talk about here are things that not only FTC has authority over, but most states, usually through their Attorney General's office, will have authority. And so what I will talk about here in the next few minutes is just give a general idea of FTC advertising law very quickly, talk about guidance that we have for marketers with regard to renewable energy claims, and this touches on residential solar, and then get into some of the issues that that agencies and marketers and other entities are dealing with as solar increases in popularity across the country. And I'll talk a little bit about some of the problematic claims, some of the laws that are implicated to keep an eye on, and just as some general background. So the basic idea with FTC advertising law, there's a lot of case law and what have you, but it essentially boils down to marketers that are making advertising claims need to tell the truth, and they need to have substantiation to back up their claims. And if the claims involve technical issues, they need to have competent and reliable scientific evidence. And another important thing to always remember when you're talking about advertising claims is that the marketers need to back up not only the express claims, the claims that are obvious to people, those are easy to identify, but also the implied claims. And in identifying implied claims, it's important to understand that what we look at when we're trying to see what a claim implies is what a reasonable consumer would take away from the ad. So it's not really what the marketer intends, that doesn't control. It's what the consumers take away from the ad. And so that's something to think about when you're looking at marketing claims out there, whether it's in the solar area or any other consumer area. Let's go to slide 3. So as part of as part of its duties under the FTC Act, FTC has lots of different rules that address some specific industry areas, and it also has some guidance for, John, you can go ahead and just click through all of those. Yeah, that's great. So it also has some guidance to help marketers avoid deceptive claims. So we have guides for things like endorsements, and we have guides for things like claims in the jewelry industry and that kind of thing. And one of the big guides we have is what we call the green guides, which are aimed at environmental marketing claims. And the These guides are, they cover both business to consumer and business to business transactions. An important thing to understand about them is that they do not set environmental policy. FTC is not an environmental agency, and that's not part of our mission. What they do attempt to address is the how consumers are likely to interpret claims and provide information about how to avoid deception if you're a marketer, especially for many of the more common claims that are out there. And as I mentioned before, the important thing to remember is how do consumers interpret the claim. So in a technical area, it's not so much important how an expert might define a certain term. We look to see how consumers understand that when they're looking at ads. So let's go to slide 4. So the green guides cover a lot of different things: recycling and carbon offsets and general claims, and there are about a dozen different issue areas. But one of them is renewable energy claims, and there's some basic principles in the guides. And John, you can just click on the text there. The first is that if you make an unqualified claim, and when I say unqualified claim, I mean a claim that doesn't have any additional information to kind of explain what it means. If you're making an unqualified claim about renewable energy, say our potato chips are made from renewable energy, they have to be made from 100% renewable energy, and they also you can't make an unqualified claim unless all or virtually all of the process was powered with renewable energy, or you've bought renewable energy certificates to match the power that you're using. Let's go to slide 5. And so I put here they're just some examples from the green guides. And John, you can just put up the text on all of these slides. And these are just some examples. So the first one, the clothing manufacturer says that their clothing line is made with wind power, but they only buy 50% wind power to cover it. And under the guides, that claim is considered deceptive because they don't qualify it to clarify that, well, we only buy 50% of wind power to match our energy. And the second example here, a car company, they purchase renewable energy certificates to match the power they use to make the seats in their cars, and they say the seats of our cars are made with renewable energy. And what the guides say is, that's okay because they have qualified it to limit it to the section of their production that involves the seats that they've covered with their rec. So there's lots of other examples in the guides, and the guides are in 16 CFR Part 260, and if you get a chance, you can look at them and go through them. But that's just kind of their general principles, and in the format is there are also these examples that people can look at. And let's go to slide 6. Some of the other principles in the guides is that if you sell recs that you generate from your own facility, or then you forfeit the right to say that you use renewable energy. And this is a very fundamental concept that a lot of people miss. So if you're the big box store and you've got the solar panels on top and you sell recs for those, so you sell away the recs, then you can't tell people that your store is powered with solar power. And that's a basic concept there, but a lot of people miss it. If there's some other guidance that you should specify the source to minimize deception, and that if you sell recs, you shouldn't say, well, we host the array. You should say we generate renewable energy but sell it to others, or something like that. So let's go to slide 7. So in the solar area, the general idea is that the claims that are generally made fall under the FTC Act. There are lots of different consumer rules that apply. In the FTC space, enforcement against deceptive claims in this area can involve orders, or if their order already exists, it might be civil penalty or if a rule is implicated. The FTC has been fairly involved in this area. A year or two ago, we put out a consumer education piece called Solar Power for Your Home. Last year, we held a conference that looked at not only consumer protection issues, but also net metering questions. And we also brought a case against a company that was doing telemarketing that was related to solar. So those are some of the things that we're doing. Let's go to slide 8. In terms of consumer education, we've put out a piece that lays out the basic, talks about some of the basic choices that consumers are faced with. I'm sure most of you are familiar with this, but generally you've got purchases, leases, purchase power agreements, and community solar is also an option out there. Let's go to slide 9. Our consumer ed gets into some of the threshold questions that consumers need to consider. Is your property, is it a right choice for solar? Are there trees over you? It encourages people to know what their electric bill is and think about how long they'll be at their address. Look into the net metering rules in their state, and also make sure that the local property rules of their homeowner restrictions don't create a barrier to solar. Let's go to slide 10, sorry. And then the basic questions that consumers need to think about with these transactions: what's the lease term? Are the payments going to increase? For leases and power purchase agreements, what is the what will be the, is there a guarantee that they'll get power? There are also lots of financing issues. One of them relates to whether you're going to do it yourself or through a company. There are also some new, the PACE financing, which is starting to expand, involves changes to your property assessment and your property taxes. It's a way to finance things, and that's something that we're looking at to make sure consumers understand what's going on. But the basic advice is to make sure that consumers get multiple bids, and that they ask their installers about installation timelines, and lots of the things that consumers would consider for any large project that they're looking at would be relevant to solar. Let's go to slide 11. And as I mentioned, there are lots of consumer protection laws in addition to just the basic deception laws that are implicated here. As John mentioned, there's some state disclosure laws, and you've got leasing and lending rules that may apply, and credit warranties and telemarketing, privacy. There are lots of things that are implicated by these transactions that will be important to consumers and important to other entities that are involved in these in looking at these things. Let's go to slide 12. So some of the potential problem claims that are out there can be the the basic questions about, well, what is the overall cost of the project going to be? How much am I going to save per month? There are also a common claim that's made is a projection of the electricity costs that the consumer is going to see in the future, and that's used to try to give an idea of how much the consumer will save. And a big question is always, well, are those utility cost projections accurate? Are they reasonable? Is there a reasonable basis for them? There are also questions about, there can be confusion about whether the consumer understands whether they'll still be paying utility bill or not. Everyone will still be connected with the utility in almost all cases here, and there may be credits that they'll get from the panels through when they're not using electricity. But sometimes there's confusion, and some of the claims can be confusing about whether the consumer will be paying a bill or not. Also, there are the claims about the amount of power that will be produced by the panel, so that's a potential issue too. Next slide, slide 13. With RECs, it's good for the consumer to know whether in a lease situation, whether they are whether they're going to retain the RECs is probably most important if you're talking about, say, a small business who gets into one of these transactions and they want to make some claims, in commerce about whether they are using solar power, and so it's important for them to know whether they have the RECs or not. So that's just something to look out in this area. Next slide. The leases have their own set of issues. There are lots of the leases involve escalating payments over time, so it's important for the consumers to know that that will be happening and exactly what's going on. That, as I mentioned before, there's a question, it's important for them to know whether there's a power production guarantee if they've got a lease or a PPA. And then there are also separate leasing rules in the Consumer Leasing Act, at least on the federal level, that have certain disclosures and provisions that go along with leases. Let's go to slide 15. Another rule that applies here is what we call the cooling off rule that applies to door-to-door sales, and it essentially requires marketers, when they're making these sales door-to-door, there are certain things they have to, pieces of information they have to provide the consumer, but most importantly, they have to give the consumer, the consumer has the right to cancel the contract within 3 days. Another important thing is that the contract has to be in the same language as the sales presentation under the cooling off rule. And let's go to slide 16. There are lots of other claims and practices and issues to think about here, and I've just listed some of them along here. I mentioned before the PACE, or the Property Assessed Clean Energy Financing, that creates a lien on the property and is essentially increases the property tax on the consumer, and if they're getting involved in that, it's important for them to know. There have been issues with Made in USA claims. Texas had a case involving that. There are questions that can come up about if I'm moving, how do I transfer the panels? Do I take them with me? Or if I don't want them, what is the charge for giving them back or terminating the lease? That kind of thing. So there are lots of these issues here. Let's go to slide 17. And John touched on some of this, but a lot of states out there are working on, there's enforcement action and there's guidance, and there's also some disclosure rules. Some are already in place, some are in the form of legislation that the states are considering. The Industry Association, SIA, also has model disclosures that they have developed, and they've been fairly active in trying to educate their members about the right disclosures and the code of conduct in the industry. And with that, I think I'll stop and pass it on and look forward to your questions later. Thanks.
Well, thanks, Hampton. You can see the link here to the green guides and more information from the FTC. Hampton reminded me that there was an oversight on the map that I kicked things off with, because there's a third category. And I know that the state of California has mandatory disclosure rules specifically for PACE financed solar offerings. So it doesn't apply to all rooftop, it doesn't apply to all community solar, but does apply to their PACE financed programs. And that wasn't shown on my map.
And John, just to jump in there really quickly, PACE is, at this point, is not a very widespread issue, at least for residential customers, but California is one of the states, one of the handful of states that has it. But since it's a kind of a new thing, it may have much more importance as it develops across the country.
All right. So Before we turn it over to Ellen Katz, who's going to tell us how many of these issues are playing out in the state of Connecticut, does anyone have any burning questions for Hampton? And again, we should have close to half an hour at the end of this webinar, should you choose to use it, for a discussion and Q&A of both Hampton and Ellen. Anybody have any burning questions right now? If you do, remember to unmute your line. And if you don't, I'm going to hand it over to Ellen.
Good afternoon.
Let me hand you the presentation,
Sure.
Ellen.
Hand me the presentation and I will jump in. All right, can you guys see my screen?
Yes, we can. Take it away, Ellen.
Terrific. Well, first of all, thank you for the invitation and it's a pleasure to be talking to you, and it's actually been really helpful for me to prepare for this because, as with so many things, there's lots of little pieces and investigations and information that we have, but pulling it all together has been a really useful exercise for us, particularly as we see the penetration of solar just increasing in Connecticut. So I'll talk to you about what we've seen and what we're continuing to watch. And as we see, I think it's fair to say we have a mature or maturing solar market here in Connecticut. Although we're probably a good comparison to Minnesota because we're not Arizona or Hawaii. Like, I don't think we'll ever see enormous penetration because of that, cold, snowy, not particularly sunny thing that goes on a lot of the year. So just to tell you a little bit about myself, I'm the Consumer Counsel for the state of Connecticut, and the Office of Consumer Counsel it's a small independent state agency that advocates for consumers on behalf of energy, natural gas, water, telecommunications. So I just want to tell you a little bit about Connecticut's solar landscape, not because you need to know all the niceties of the green bank, et cetera, but to understand the issues we've seen and the things we are watching. I think you sort of have to understand how we have a regulatory construct that's a little bit unique. The Connecticut Green Bank is the nation's first green bank, and they define that as an entity that accelerates the deployment of clean energy using limited public dollars to attract private capital investment in clean energy projects. And they strive to make energy more affordable and accessible to consumers. So the program, Connecticut Solar Program, is administered and managed largely by the Connecticut Green Bank, but the Green Bank is a quasi-public agency, so it's not a regulatory agency. They do have a really excellent website that lays out all the different options and a lot of consumer information on there. I think what's a little bit unusual about it is because they're not a regulatory agency, they don't create or license contractors. What they do have is they have a set of guidelines for solar contractors to follow, and in order to become an eligible solar contractor, you have to sign their contract RFQ, I think they call it, the program RFQ. And if you sign it and then you become eligible, then you have access to the Green Bank's incentive programs. And so it's sort of a carrot, if you will, that if you want to be able to offer your consumers rebates, you have to sign up as an eligible contractor and agree to the terms and conditions that the Green Bank puts on them. But the licensing is actually done by the Department of Consumer Protection, and they license the different kinds of contractors, I'll talk about that in a minute, that work on consumer solar projects. And that's sort of the basic construct. And at the Office of Consumer Counsel, we receive complaints. People will call us occasionally, and of course we always try to help them, but we don't, we really represent consumers as a class. We don't handle individual complaints. So we generally will direct the consumer to the right entity, usually Department of Consumer Protection. We don't get a lot of complaints about solar issues. Once in a while, and interestingly, we got one from a very sophisticated consumer recently who was very upset that when he leased his solar panels, he wasn't also getting the RECs. So we'll talk about that later, but the renewable energy certificates, which I assume folks know what that means. So, you can get some really sophisticated consumers who are upset about RECs to people who are wondering why there were holes punched in their roof in terms of the breadth of complaints. Our Department of Energy and Environmental Protection is only really tangentially involved. They set some of the policies or support the policies that have led to the proliferation of solar and supporting the legislative efforts to get subsidies for solar customers. And then PURA, which is the Public Utilities Regulatory Authority, is what we call our PUC. And they actually have they have a very limited role because this program isn't regulated per se by PURA. It's administered through the Green Bank, although their Consumer Services Division fields all kinds of complaints related to energy issues, and they will send them over to DCP Consumer Protection. They actually do have one docket open now that's tangentially related to the banking of RECs and a failure of a competitive electric supplier to cash them out appropriately. But since you're vertically integrated, you won't have that issue. And also on this slide, I should mention our Attorney General's office, which also does some investigations in coordination with DCP, and I'll tell you about that. But I think it's important to understand that because I think it's sort of an unusual regulatory construct. And it relates to the consumer protection issues we've seen. So just a little bit on how the incentive program works is there's a residential solar incentive program, the RCIP, which gives money to the consumers who either purchase or buy or lease residential solar projects. And so you either get an incentive up front if you're buying a solar installation, or you get incentive payments through the term of the lease and the power purchase agreement in order to encourage rooftop solar. But the RECs are held by the Green Bank. So the Green Bank then sells those to the utilities who are obligated to purchase them in blocks, and then that money flows back to the Green Bank to fund the RCIP program. So it's sort of a self-perpetuating cycle. So what does the consumer need to know? And I will say, and I'll say this repeatedly, what our experience and what we've heard from the folks at the Green Bank, and I think it's consistent with what Hampton said, is that educating the consumer is the hardest part. And the first one up there is the electric price escalator is probably one of the biggest bugaboos, at least to us, because there's no set electric price escalator, and that's setting the basis for what your solar savings are going to be. A lot of it is based on, well, what's the price of energy? How much is it going to escalate? And there's no guidance or standards for what that price escalator should be. So I think Hampton said something. Oh no, John was talking about how there are required disclosures in certain states, and if that was one thing we could do, I think we would love to see that set. Like, this is the price escalator that everyone has to use. So whether we're right or we're wrong, everyone's getting the same set of assumptions. What the Green Bank has told me is that if one of their contractors is going above 3%, then they will talk to them and say, hey, we think your energy price escalator, which is built into the savings, is too high. But again, there's no real standard for that. The other thing that we sort of keep an eye on is net metering. Does your state reimburse you at the retail or the wholesale rate? This makes a huge difference in the savings. And then as consumers are being, as they're making estimates right now, for example, in Connecticut, there's a push to look at net metering, reform net metering, maybe go to some sort of tariff situation, which I would assume contractors are probably not talking to consumers about right now, and in part because it hasn't happened yet. And second, I don't know what you would say to someone other than your net metering benefits may well diminish in the near future. But that's a problem with the solar savings and those assumptions. And Hanson also talked about the solar system output. Is that correct? Are you oversizing the system? Are you undersizing the system? And is there some guarantee that your system will produce the amount of electricity that's quoted to you? And then government incentive. I talked before about the RCIP program, and certainly that's set for a number of years, but there have been the federal incentives have come and gone, and so how does that play into it? So this first square, this assumptions about solar savings, are where we really have a lot of concerns about what consumers are being told. And you know, anytime that there's a sales pitch, I think there's a risk of high pressure sales tactics, overstating savings or trying to sell to a poor candidate, and a poor candidate based on house, you know, the position of the house, the age of the homeowner, and not to be presumptuous, but you know, if someone's planning on moving in 2 years, that maybe should be factored into, at least in their own mind, as to what the potential savings are. And then we've actually seen companies trying to sell to renters, which is highly inappropriate unless you have a very unique kind of landlord. So we also want to make sure that homeowners are adequately informed and know the questions that they need to ask. Is the roof properly positioned? And I think that's an easier one than how much tree cover there is. You know, Minnesota's a lot like Connecticut. There's a lot of heavy tree cover. So just because your house is facing the right way doesn't mean that at the appropriate time, the trees aren't going to cast a shadow on your panels. And then what is the age of your roof? If you're going to need to replace your roof in a couple of years, then that's going to create additional costs, obviously, because you're going to have to remove the panels, and that's usually almost always borne at the consumer's expense. And then to what extent does your insurance cover the solar system? Does it cover it at all? You know, if your roof starts leaking because your solar panels were improperly installed, I don't think that's covered by homeowners, but it's a question. And certainly there's the question of warranties and who's responsible, and then the maintenance and repair, and sort of more unique questions like electrical surges, which happens, you know, when there's storms, and there's been a lot of storms lately where we've seen power outages, which leads to potential power surges, and that can completely fry your system. So who's responsible for that? This is the kind of really minutia that can impact the efficacy of the system and how much the consumer's receiving as far as the savings. But, you know, again, it's not only is it really hard to explain a lot of these things, but it's a pretty deep dive. I will say there's a really interesting resource. Google Earth has a feature where you can do a search for your house that will tell you how, if you're a good candidate for solar panels. It's called Project Sunroof, that can help you map your potential solar savings. So those are the kinds of things we suggest consumers make sure they do a lot of research on their own. And the issue with maintenance, I think, is a big issue in Connecticut, because it's not just cite it and forget it. You have to keep them clean. You have to do some regular maintenance. In Connecticut, as in Minnesota, does the consumer know you have to clear them of snow? Do you want to pay extra for bird proofing? Should you pay extra for bird proofing? So, and these are things that we are working as a state on getting consumers to think about. And then when it comes to hiring a solar installer, one of the good resources is NABCEP, North American Board of Certified Energy Practitioners, which maintains a certification program for installers. So that's one good resource. In Connecticut, we have Energize CT, also maintains a comprehensive list of solar installers across Connecticut. And of course, if you want to get the RSIP, the Residential Solar Incentive Program, you want to be working through the list of eligible contractors on the Green Bank website. And so when it comes to what is a qualified installer, again, it's to me a little bit of a patchwork as to what's required. Anyone in Connecticut with a home improvement license, an electrician license, or PV1 license can install solar panels. However, only an electrician can interconnect your system to the grid. So the question to ask an installer is how much experience do they have, and who's taking care of the permits? Are they following all the rules and regulations? And obviously there has to be an electrician involved somewhere in order to interconnect it to the grid, but you could be dealing with a home contractor versus a PV1 contractor. And one of the things about if you use a home improvement contractor and there's an issue, if you're willing to sue your contractor, that does give you access to the state's home guarantee fund, which has something like of a $10,000 to $15,000 limit, but it's sort of a backup for consumer complaints. So again, I think that's one of the problems, is there's sort of this patchwork system. And these licenses, by the way, are administered in Connecticut by the Department of Consumer Protection. So these are really some consumer marketing concerns. What kind of miscellaneous extra add-ons are they charging you, such as I mentioned, bird proofing or maintenance or some kind of updating? Are all the charges included? We have seen a lot of problems with door-to-door sales in Connecticut in general. We generally warn consumers, and it comes up in the context of competitive electric suppliers quite a bit, and we worry about the same door-to-door aggressive marketing tactics being transferred to the solar panel world, because someone's knocking on your door and trying to sell something. So we warn consumers to be wary of who the salesperson is and make sure that there's some kind of badging. I mean, that would certainly be ideal. We have that in the competitive electric supplier context. We do not have that in the context of solar installers, but if I were starting from scratch, that would certainly be something I would think about. The Green Bank has, their RFQ has marketing guides for contractors to follow. But again, if you have a solar contractor that's operating outside of the Green Bank framework, which admittedly we don't see a lot of, you can still find that, there isn't a lot of rules. But there is a way, and we tell consumers this, to make sure that the installer, the contractor, has a valid license. There's actually a website, elicense.ct.gov, that you can go and make sure they're properly licensed. And as we talked about overstated assumptions and overstated savings, we urge consumers to do their own research on the state and federal websites and to read the contract to make sure you're the beneficiary of the rebates. Some of them may have the rebates going to the installer. So, and the overstated savings, as we talked about before, the electric industry, it's not static. It's a very dynamic field, which means prices are subject to change. So, it's again hard to make sure the consumer can really understand all the ins and outs of the pricing models. But uniform assumptions, like we said before, would be a best practice for a state. I do want to mention our Attorney General is currently investigating. Some solar companies have gotten into this practice of going online and with our largest utility. A third party can go and open an online account. All they need is your account number, and that immediately gives them access to your usage data. It doesn't give you access to their financial information, but we've seen solar installers opening these accounts with or without the consumer's consent. It seems to depend, and then looking at their usage to try to, determine what their savings might be, which is certainly an appropriate activity. But what makes us concerned is that this is happening in times without the consumer's consent. And then these online access portals to consumption, they sort of go on forever. Like once you open it, there's no process for closing it. So, or no requirement that it be closed. And that certainly raises consumer privacy concerns. And so our Attorney General is investigating that, and they ultimately will probably end up going to the solar companies that are engaged in this, but they are also going to probably talk to our utility as well, because it just seems like it shouldn't be quite that easy. Okay. So like I said, consumer education is the hardest part. And the mandatory disclosure requirements would be nice to have, but these are sort of, when we put together consumer information, these are the sticking points. What's really hard to explain to people. And I know this isn't really about explaining the different kinds of systems, so I'm going to go through these quickly, but consumers need to be aware when they're buying a system that it can take upwards of 10 years to pay for the system. Although this is the easiest form to understand. The mechanics of this are pretty easy. You pay for it, you get an incentive up front, and then once you pay it off, you kind of get the benefit of the savings. Where it's a little bit harder on the leasing of the PV system, where there's little or no upfront costs and you start saving right away. But the caveat is that as long as the energy produced results in a utility bill savings that's greater than your monthly lease payments. So, the incentives include the tax credit and the rebates, but the recs stay with the Green Bank, assuming you do that. And the escalation schedule for the payments is somewhere usually between 2 and 4%. And, again, when you're comparing your escalating payments compared to the escalating price of electricity, that's when it's a bit of a gamble. Particularly in Connecticut, we saw prices fall sharply in the last few years, and they're starting to creep back up again. But they're not, and I hope they will not continue to increase at 3% a year, but we'll see. And then there's the solar PPA, which the primary difference is there's no fixed monthly fee, and you're charged by how much you're produced. The idea is that this charge is less than the average cost per kilowatt hour that the customer's paying the utility incentives. So solar leases and PPAs are losing some market share as solar panels when solar technology becomes cheaper, but it still becomes it's still the majority of what we're seeing. So, and then there's questions about selling a home with solar panels. I will say, we pulled up next to our house last weekend, and our neighbor was installing solar panels, and my husband said, "God, that looks awful," and I said, "Gee, that's really neat." So, consumers need to think about this as to the impact on sales. The estimates are that depending on the state and the size of the system, solar panels can add anywhere from $5,000 to $30,000 to a home value, but not if you're selling to my husband. So, and removal is just another cost you got to consider. And Hampton touched on some of these, so I won't repeat them. I did want to just mention one thing that was particularly successful in Connecticut at pushing solar out was we had a Solarize program, which was a program run by the Green Bank, which was a community-wide program where essentially there would be bids, and whatever contractor had the best bid would then be sort of the preferred vendor within a town and would have the imprimatur of the town's approval. And through economies of scale, the town would pre-select solar installers, and that technology would be offered to homeowners at a discount. And it gave the contractors a guarantee somewhat of an amount of customers. And, in a number of years, there were 2,000 homeowners were resulted in 17 megawatts of solar panels. So it was a good way to really push it out. There's a bit of a cautionary tale, though, involved in that One of the main contractors, which was a company that was called Be Free in the Solarize program that did a number of towns, basically was engaging in misconduct. They were signing contracts for one type of equipment and they essentially installed another. And then the way the RCIP program works is you have to do certain kinds of activities before you can get the incentive, and they were misrepresenting that the equipment had been installed and they were getting the money before the equipment was actually installed. So there was a settlement under which they quote unquote voluntarily left the program, and DCP got involved and ultimately suspended their homeowner's license. The reason it's a little bit of a cautionary tale, if you will, is that that was one of the vendors who did entire towns, and this company is now out of business. So it raises all sorts of questions about who is supposed to, protect these consumers, or what do they have as far as a backup. Now, I've gotten the other pushback on the other side of the coin as well. If you install a pool or a new roof and your contractor goes out of business, you're sort of in the same boat. But it does, it starts to get a little uncomfortable when a community's picked a particular vendor as a preferred provider and that person's gone out of business. No great answers, but it has been, to me, sort of a bit of an eye-opener. And I've also heard from the Green Bank people that because of the competition from the less expensive Chinese panel manufacturers, a number of the American panel manufacturers have gone out of business as well, taking with them their warranties. So again, there's some exposure for the homeowner. I will say we don't have a community solar program yet in Connecticut. We are just approving a pilot that's just getting off the ground. And one of the examples we've been looking at as a place with a robust community solar program is Minnesota. So, I may ask you to give me do this in reverse, and you guys can tell us about your success in community solar. So, bear with me one second. So just final takeaways: assumptions make all the difference. Make sure consumers understand what it takes to be a good candidate, and that they do their own research. We urge consumers in every context not to feel pressured by door-to-door sales, but to take the information, go check the website, and then go to the Green Bank, which is the source of information in Connecticut, and then again do their homework on making sure buying or leasing, whichever one is the best model for them. So at that point, that's what I have, and I'm happy to take questions and interested in the dialogue.
Great. Thank you, Ellen. So we have this time blocked off for another 26 minutes, and as promised, we've left plenty of time for our friends in Minnesota to ask Hampton or Ellen questions. You're welcome to ask me questions too, but I think this is a great chance to benefit from the experience that Hampton and Ellen have. And as I said, if you would like to ask a question, I think we have a small enough group that you can just unmute yourself and speak up. And if we start to sort of talk over each other, we'll use the chat feature. But the floor is open now if anyone would like to ask questions. And if people are shy, I'm going to have a question. Okay, well, I will start.
Hi, John. Can you hear me?
Yes. Yes, we can hear you.
This is Michelle Roger. I had a question for Hampton. When you were talking about the different claims, I was wondering if the FTC has guidance on additionality. So we're seeing things around procurement where there's a question about if those renewables are in addition to what would have been on the grid otherwise.
We don't have guidance on additionality with respect to renewable energy. It was considered in 2012 when we updated the green guides, but it was just there was just given the issue, we decided not to weigh in on it. We do have additionality on carbon offsets, and we have an example in the Green Guides about regulatory additionality. But no, we don't. In this area, we don't have any guidance.
So Hampton, this is John Chanot. Does that mean if someone was making a carbon claim?
Yeah. So the example we have in the Green Guides is, if they're selling carbon offsets, but they're basing that, I think in the guides it's like a landfill methane capture, and if that methane capture is required by state law already, then we would consider the claim for the carbon offset to be deceptive, because it's not it's not additional to what is already being required. Additionality is for at least for me is kind of this mind-bending exercise, but for carbon offsets, for that particular example, the commission felt that it was on firm ground and saying that would be deceptive. But particularly in the renewable energy area, we didn't get into any particular examples to say that one practice was deceptive or another practice wasn't. So. I did have on the chat screen, I guess maybe it only went to me, but someone asked about the cooling off rule, and just who is covered, and so I just wanted to clarify that the cooling off rule is it covers anyone who is any sale, lease, or rental of consumer goods above, I believe it's $25. That's being done, primarily door to door, but it also applies to sales that are made away from the normal place of business. So it would definitely cover, this kind of transaction.
So I'll jump in while people consider their questions. This one's for Ellen, and I'm curious, Ellen, if you think under maybe different circumstances, a solarized kind of program could be a force for raising consumer protection standards. That you've got an installer who would really love to get, I don't know, 500 customers in one fell swoop. That you might be able to impose some higher standards on the vendors that want that solarized contract.
Yeah, and in fairness to the Green Bank, they do have their RFQ standards, and it's not like it's not the Wild West because of their activities, but yeah, it's Monday morning quarterbacking. But if we were going forward and doing another program like that program has ended, we might consider, and I wasn't involved in the program, so I don't know to what extent they looked at the financial viability, the past history of the company. Of course, that was really when it was a burgeoning area, and I mean, it's still not completely mature, so it's not necessarily like you would have known that a particular company might have had issues. But you could take a deeper dive into the history and the fiscal strength of the company or the vendors that are being picked. But you could certainly layer on top of that requirements about, like I said, the assumptions that you are requiring and the escalator factors and things like that. So you're right. It's a good point. It's a carrot. It's a great opportunity. So and the benefit to consumers in that case was a significantly, a lower price, and the convenience of having the guy go down the street and install one after the other, and everyone's sort of sharing the experience. But that's a great idea. So.
All right. So back to Minnesota. Do you have any questions there or any stories you want to share with us?
I would be curious in just hearing about how community solar is working in Minnesota, since community solar is very different from state to state, and even within states. There are lots of, when people say community solar, it can mean a lot of different things. So I was curious about that.
Yeah, as I said, I'm interested in it too, because that's where we're expanding.
Anyone in Minnesota willing to unmute themselves and share a little on that?
Can people hear me?
Yes.
Okay, good. This is Ian in the AG's office. I think, you know, one point that I would make that is something that at least I've noticed in community solar that we're having here that relates to some of the points that Ellen made is the way that community solar is being billed right now is you're billing for the energy. They're billing for the energy that is produced by the panels. So that if the panel produces 10 kilowatt hours, that's what you're paying for, and then that's offsetting your energy usage. So the reason I bring that up is I think it raises another angle on the increased the increased rate that is being baked into the assumptions, because these billing contracts have an adder. So, for example, the price will, as you're billed at, 10 cents a kilowatt hour, for example, and then that will increase by some percentage every year, 2%, 3%, whatever. But theoretically, as the price of electricity increases, if it increases at a higher rate, you'll be okay, or even saving more. I hope that what I said made sense. If we're just seeing that as a different angle on that whole thing.
Yeah, that made sense to me. So via the chat box, we're getting a question for Hampton. Hampton, do you think you could expand on transferability issues? What issues are involved there with transferability?
Sure, it's just a broad question, and it comes up. It comes up with a lot of situations where the consumer, they sign a 20-year lease and then they sell the house at year 15, and so they're trying to figure out, well, do I take the panels? Am I moving, down the block, and can I take the panels with me, and how much is it going to cost? And usually there's a fee associated with it. So there's that issue. More commonly, they're not going to take them with them, and so you see stories and concerns raised by consumers that they feel that it's more difficult for them to sell their house because they have these solar panels that are under a lease contract, and the buyer, some buyers may not want to assume the lease, what have you. So that's the transfer of the property or whatever is what I'm kind of referring to there, and that's been that's a concern, whether the consumer understands what they're getting into with the contract, whether they understand the fees that are associated with moving the panels, or the fees associated, or the penalties associated with breaking their lease contract because maybe they're having trouble selling the house, and they need to move, and they need to get rid of the solar panels. So that's what I was referring to.
And I'll just add that the consumer's rights in those transfer circumstances are one of the categories of things that are being explained in some of these mandatory disclosure requirements, so that every sales pitch or contract with the consumer clearly spells that out in the states that have adopted some mandatory disclosure requirements. Did you want to add anything on that, Ellen? I know you did mention it, but maybe it's covered.
Mandatory disclosure requirements?
No, the transferability stuff.
Oh, yeah. Yeah, you know, it's just one of those areas that we just don't have a lot of information. We don't have a lot of standardization. And so we're sort of learning on the ground as consumers face these issues. So I don't have any great advice, but it's rightly being raised as an issue.
Last year when we did our conference or our workshop, we had a rep from the Massachusetts AG's office, and this was one of the bigger issues that she was dealing with, at least up there, in terms of these transfer issues. And also the other issue that Ellen mentioned before is, you know, what happens when the contractor goes out of business, and you know, what do you do? And maybe as the solar penetration increases and there are more and more vendors out there, it's less of a big deal. But if you're in a state where there are not a lot of providers, then, you know, that can become a bigger issue. Just trying to figure out how to deal with it and how to find somebody to you know, deal with the issue in terms of either if you need to get rid of the panels or you need them serviced and that kind of thing.
Yeah, that is an issue that we have. It's obviously on our minds because of, you know, one of the major contractors going out of business. I don't have a whole lot of information on it, but the willingness of another solar installer to service your panels or do maintenance on them, you know, there's certainly no guarantees of that. And then again, that raises consumer protection, you know, alarms in my head, because then I just feel like the next guy is going to come in and say, it potentially might say, well, geez, you know, they undersized it or something, and we got to redo everything. And this is just one of those areas where the consumer is at such a knowledge deficit that, you know, it can a lot of potential to take advantage of consumers. Although I know the Green Bank would want me to add that most of our installers are, you know, really great and they work with them really closely, but it's the outliers that create the concerns for me.
I think Susan had a follow-up question, and it looks like she's unmuted herself. Susan, did you want to ask a question, or do you want me to read it?
This is Susan McKenzie. On the transferability issue, I was curious about the transferability of the contract. Well, the sale of the garden, if you have a community solar garden and they sell the garden, what sort of disclosure should the subscriber or the ratepayer have about that aspect, that the contract can be sold? I guess in the Excel program, it wasn't included in the contract signed by the subscriber, and then they had to go back and change it. So I was just curious, have you dealt with that issue when garden operators start to sell gardens? What happens? Any rules or disclosure policies?
This is Hampton. I think, well, in Minnesota, there, as I understand it, there's a statute and there's specific rules about disclosure. So, you know, that would be the applicable provision there. Elsewhere, as I mentioned, the community solar practices are so variable and the rules are so different from state to state. It would depend on what was there. But I don't know if Ellen has more info on that.
No, as I said, we don't have any community solar in Connecticut yet. It's just getting off the ground, but it's certainly making me think we need to add that to the list of questions we need to have answers to if we're going to keep moving forward in this direction. So
I'm afraid I can't add to it either.
Yeah. That's the problem with this is it's very easy to issue spot, but it's very hard to come up with solutions.
Mm-hmm.
Yeah, Susan, I don't know if it's peculiar to the kind of aggressive uptake of community solar in Minnesota. Here in Colorado, we have a good bit of community solar, but I actually haven't heard too many examples of the solar garden itself being sold, or the ownership of the solar garden being transferred. So I just, you know, if you want us to follow up, we could look into that, but I don't have anything to help you with today.
Okay, no, that's fine. It is, I don't know that it's an issue in Minnesota, but 1 in 3 gardens under Excel's program have been sold at least once. It doesn't come back to the commission for approval, but it is happening. So I was just kind of wondering if there was anything that we should be made aware of. That's so.
1 in 3. Wow.
Yep. So I don't know why, and I don't understand it, but you don't have to look into it.
Okay. Well, I'm not seeing any other questions
John.
here.
John?
Yes.
I had a question for Ellen related to, you didn't really talk a lot about the net energy metering or billing for your customers, but I was wondering how Connecticut has handled some of the questions that were raised in 2014 about how taxes are applied to the net energy billing. My understanding is the IRS didn't come out with formal guidance on that, and we're seeing it handled differently by different utilities here in Minnesota.
Oh, that's a great question. I'm afraid I don't have an answer, but I'm happy to look into it for you. I mean, I know how it appears on the bill. The net metering, you get, you know, a net metering credit against your usage, but I don't know how the tax implications of that. But I'm certainly happy to follow up and see what I can find out.
Yeah, that's how net energy billing works in Minnesota as well. But there's a question about if that credit is a kilowatt hour versus a monetary credit, and if it's a monetary credit, the way that taxes are handled, there can be tax implications.
And that would be relevant for your value of solar tariffs. Is that why you're asking the question?
Or is it relevant to the homeowner?
It's relevant to, yeah, the net energy metering of any customer that has a rooftop, or well, not even rooftop, but any any distributed generation. That's
I mean, is it income?
So the way that it's treated by our Department of Revenue is if it shows up on the bill as a dollar amount, it is treated as a transaction that is taxed. And so, I don't know, I can go into more detail on it, but so it just matters, like some utilities basically wait till the end of the month and have the bill show total kilowatt hours and then subtract or net out that and then set the monetary amount. And some of our utilities are showing it as basically daily transactions that they then net out over the bill cycle as dollar amounts rather than kilowatt hours.
Yeah. Well, I happen to have, this is a sample bill for that. I was looking at it before. I just put it up on the screen. I don't know that, I don't even know if that's on our radar, but I will find out. So. Yeah,
Michelle, I will tell you without claiming any expertise, least of all on taxation. I do know enough to tell you that other states, other utilities have reached a different conclusion. And the last time I checked on it, the IRS was doing everything it could not to weigh in on the issue. That there are, for example, the best known, or the predecessor to Minnesota's value of solar tariff, was Austin Energy in the state of Texas. And Austin Energy awards a bill credit based on their own calculation of value of solar. It's a dollars and cents credit but only against their bill. And they've maintained that that's not the same as paying the customer, and challenges to that kind of arrangement are the challenges that have been posed to the IRS. People have asked the IRS to weigh in on whether that's taxable income. And as far as I know, they have yet to offer an opinion on whether that's taxable income under federal law, which means if they don't weigh in, then states under state law can obviously make their own decisions, but they're not all going to make the same one.
Yeah, and just to add to that, I know in Connecticut, you can bank any excess kilowatt hours you have per month, but then there's a true up. You can only bank them till like March. That's when the sort of the year ends. And then every March is a true up, and essentially any excess kilowatt hours you're paid only the wholesale rate, not the retail rate. And so I don't know how that figures in, but
we
have
that as well.
Yeah,
having for some of our customers
gone through all the consumer issues with the Green Bank and preparing for this, that issue didn't come up. So I suspect we're not taxing it, but I can confirm that.
I don't know what you're doing in Connecticut, but my understanding, I haven't looked at this issue recently, but I looked pretty closely maybe a year or two ago, is that end of year payment is in all likelihood taxable income, at least under federal law. But a bill credit where the credit offers a value in dollars and cents rather than kilowatt hours, that's where the IRS hasn't weighed in the content, within a bill or within a billing cycle where the utility has not written a check to the customer. The customer is not putting money in the bank, that the IRS has not, at least to date, has not issued any guidance that is taxable income, but the question has definitely been posed to them.
Well, I will follow up on that, and I'll send the answer back through you, John, because now I'm curious.
Thanks. And I would just note that for us here in Minnesota, that question of taxing the transaction is not that's actually a revenue question, not a commission question, but how the bill is calculated and how that net energy bill credit shows up, that is something that is within our jurisdiction.
Yeah.
Well, we have reached the end of our scheduled webinar time. I hope this was useful to all of you. We will be following up with a link to the recording. We will be sharing the slides that you've seen today, and I am more than happy to serve as a conduit for any follow-up communications or questions that arise that we weren't able to answer today. Michelle Rebholz, is there anything you wanted to close with?
Just a big thank you to everybody, the presenters, and everybody for participating. It was a really good discussion, I thought. Brought up a lot of good points.
Well, on behalf of the speakers, you're quite welcome. We're always happy to help and look forward to doing so again in the future. I'm just going to close this down. Thank everybody for attending. I hope you have a pleasant weekend and that we can stay in touch.